He didn't think he was starting a legal case. He thought he was ending one. His name was Richard, that's what he told me on the night we met at a fundraiser gala in downtown Vancouver. Richard Holloway, 51 years old, recently separated, co-founder of a real estate development firm that had built half the luxury condos lining the North Shore waterfront. He wore a navy suit that probably cost more than my monthly rent, and he laughed at his own jokes just enough to seem confident without being arrogant. I was there representing the nonprofit I worked for, a housing advocacy organization in East Vancouver. We were invited because his firm had just made a sizable donation to affordable housing initiatives in the city. I remember thinking that was a good sign about his character. I was 32. He was 19 years older than me, which I noticed but didn't think much about at the time. He was charming in a quiet, unhurried way. He asked about my work. He listened when I answered. He remembered what I said when he circled back to it 20 minutes later. Those things mattered to me. We dated for 4 months. It was not dramatic or intense. It was comfortable in the way that things are when two adults choose each other deliberately. He picked me up from my apartment in Kitsilano. We went to dinner in Gastown, walked along the seawall, drove up to Whistler one weekend in October when the leaves were turning. He met 2 of my friends. I met none of his, which I noted but accepted because he explained that his social life had contracted significantly since the separation. He had an adult daughter from his first marriage. He did not talk about her much. When I found out I was pregnant in November, I was alone in my bathroom at 6 in the morning, and my first reaction was not fear. It was a kind of stillness. I sat on the edge of the tub for a long time. Then I called him. He answered on the 3rd ring. His voice was careful when I told him. Not cold exactly, measured. He said he needed time to think. I said of course. He called back 2 days later and asked if we could meet in person. We met at a coffee shop on West 4th. He sat across from me and folded his hands on the table and told me, in a very even tone, that he was not in a position to become a father again. He said his life was in transition. He said he cared about me, but that this was not something he had planned for or could commit to. He said there were options, and he wanted to support whatever I decided, financially. He slid a folded piece of paper across the table. I opened it. It was a number. $60,000. Deposited within 72 hours. No conditions. If I made a specific appointment at a clinic he had already researched and written the address of on the back. I looked at the number for a moment. Then I folded the paper and put it in my coat pocket and picked up my coffee. I'll be in touch, I said. He nodded like we had just concluded a business meeting. He left first. I drove home along Broadway and did not cry until I was parked outside my building. Then I sat in the car and cried until I felt empty, and then I went upstairs and made tea and opened my laptop. I had my first ultrasound 2 weeks later. The technician moved the wand slowly, and then paused and said, with a kind of careful cheerfulness, "So there are 2. Twins. A boy and a girl, as it turned out, though I wouldn't know that for another 8 weeks. I called Richard that evening. He did not answer. I texted him. He responded the next morning. I thought you had made a decision. Can we talk? We talked. He was not angry. He was worse than angry. He was disappointed in a way that made me feel like an inconvenience he had not properly accounted for. He said twins complicated things significantly. He said his firm was in the middle of a major development deal, and that any kind of legal or financial exposure at this moment was something he could not afford. He used the word exposure to describe his unborn children. I remember that specifically because I wrote it down that night in the Notes app on my phone. I wrote it down because I knew, even then, that I was going to need to remember the exact words he used. His father called me 3 days later. I did not know his father had my number. I do not know how he got it. His name was Gerald Holloway. He was, I later learned, the original founder of the firm that Richard co-ran, the man who had built the company from a single commercial property in Surrey into what it was now. He was 74 years old, and he had the kind of voice that expected to be obeyed. He did not waste time on pleasantries. He told me he was aware of my situation, and that he had spoken with Richard, and that the family had agreed on a resolution they believed was fair. He named a number, $2 million Canadian, wired to an account of my choice, structured as a personal gift to avoid tax complications, with a single condition, a signed agreement, prepared by their legal team, in which I confirmed I would not seek any further financial support from Richard or any member of the Holloway family, and in which I agreed not to identify Richard as the father of my children in any legal document or public forum. He spoke for about 4 minutes without pause. When he finished, there was silence. "Mr. Holloway," I said, "I'm going to need you to not call me again." I hung up. Then I sat at my kitchen table for a very long time. $2 million is a real number. I want to be honest about that. I am not someone who grew up with money. I grew up in Hamilton, Ontario, in a semi-detached house with my mother and my grandmother after my father left when I was 9. I put myself through university on a combination of student loans, OSAP, and part-time work at a grocery store. I moved to Vancouver because I believed in the work my organization did, not because I was building wealth. $2 million would have meant that my children never worried about anything. It would have meant I could stop worrying about anything. I thought about it for exactly one night. The next morning, I called a family law lawyer named Claire Arsenault, whose name I had found through a legal aid referral service. Her office was in a low-rise building near Main Street. She wore reading glasses on a beaded chain, and she had a Montreal accent, and she listened to everything I said without writing anything down, which I later understood was because she was memorizing it. When I finished, she looked at me over her glasses. "Did you accept any money from them?" she asked. "No." "Did you sign anything?" "No." "Good," she said. "Then we're in a very clean position." She explained the process. Under the Family Law Act of British Columbia, both biological parents are legally responsible for the financial support of their children, regardless of the nature of the relationship, regardless of whether the parents are married, and regardless of any private agreement that attempts to circumvent that responsibility. A private payment in exchange for a signed waiver, she told me, would almost certainly be unenforceable against a child support claim, because in Canada, child support is considered the right of the child, not the right of the parent, and a parent cannot legally sign away a child's right to support. "What about the NDA-style agreement they proposed?" I asked. "Unenforceable as it applies to child support," she said. "They can ask you not to discuss the relationship publicly, but they cannot legally prevent you from naming the father in a paternity or child support application. That's protected." She also told me something that Richard's father had clearly not expected me to know. In British Columbia, prenatal paternity testing is available through court order during pregnancy when paternity is disputed. We could begin the process before the children were even born. I asked her what she thought we should do. She took off her glasses and set them on the desk. "I think," she said, "that we should file first." We filed a notice of family claim in BC Supreme Court 12 days later. I was 22 weeks pregnant. The claim named Richard as the presumed biological father and requested both a declaration of parentage and a child support order calculated under the federal child support guidelines, which in Canada are based on the paying parent's income and the province of residence. Claire had requested financial disclosure as part of the filing. Richard's lawyer, a senior partner from a firm in downtown Vancouver whose name I recognized from real estate litigation news, responded within a week with a letter suggesting that my claim was premature, that paternity had not been established, and that his client denied any current financial obligation. Claire called me after she read it. "They're going to try to delay on paternity," she said. "That's expected. We'll get a court order for testing. Can they fight that?" "They can try. They won't win." The court granted the order for prenatal paternity testing 8 weeks before my due date. The test required a blood draw from me and a cheek swab from Richard, who appeared at the testing facility in Burnaby, accompanied by his lawyer, and did not look at me once in the waiting room. The results came back in 11 days. 99.97% probability of paternity. Both children. I was alone when Claire called to tell me. I was sitting in the rocking chair I had bought secondhand from a Facebook Marketplace listing in New Westminster, assembling it in my living room. I set down the instruction sheet when she told me, and I looked out the window at the rain coming off the mountains across the inlet, and I felt something I can only describe as a quiet settling, like a question that had been hovering in the air, finally finding a surface to land on. "Now we move," Claire said. Richard's lawyer filed a response to the paternity results that was, by any measure, remarkable in its persistence. They did not dispute the result. Instead, they argued that Richard's income should be calculated based on his salary from the firm rather than his total income, which they characterized as variable and difficult to quantify. Claire requested full financial disclosure, 3 years of tax returns, corporate filings, shareholder distributions, and a list of personal assets. What came back, after 2 court appearances and a judge's order compelling disclosure, told a more complete story. Richard's T4 income from the firm was modest by design. His actual financial picture: shareholder dividends, real estate holdings in West Vancouver and the Okanagan, a portfolio of private investments placed his total annual income at significantly higher levels. Under the federal child support guidelines, child support for 2 children is calculated as a percentage of the payer's income. The number Claire arrived at, for monthly support, was not the $60,000 one-time payment Richard had first offered me. It was a monthly obligation, ongoing, for each child, for as long as they were dependents. Gerald Holloway's lawyer called Claire's office the week before the final hearing. They wanted to negotiate. Claire came to my apartment to discuss it. She sat at my kitchen table and walked me through the offer. A structured settlement, a lump sum designed to replicate several years of support payments in exchange for a cap on future obligations. It was a large number. It was also, Claire explained, less than what a court would likely order over the full duration of support, especially if Richard's income continued to grow as the firm's development pipeline expanded. What would you recommend? I asked. She considered this in the way she always did, slowly, without performing the thinking. I would recommend we let the judge decide, she said. We went to court on a Tuesday in March. The courtroom was a high-ceilinged room in the Vancouver Law Courts building on Smythe Street. Richard sat at the table across from mine with 2 lawyers. His father was not present. I had asked a friend to come sit in the gallery, and she was there when I walked in, and she gave me a small nod that I held onto. The judge reviewed the financial disclosure, the paternity results, the guidelines calculation, and the submissions from both sides. She asked Richard's lawyer several pointed questions about the income characterization. His lawyer's answers became noticeably less crisp as the hearing progressed. When the judge delivered her decision, she did so in the measured, unhurried language of someone who has considered a question thoroughly and arrived at a clear answer. She found that Richard's total income for the purpose of the guidelines calculation included his shareholder distributions and investment income. She ordered child support at the amount Claire had calculated. She also ordered a contribution toward my legal fees, which in BC family courts can be granted when one party's conduct has unnecessarily prolonged proceedings. Richard's face did not change during the ruling. He stared at the table. His senior lawyer made a note on a yellow legal pad and then set down his pen. Outside the courthouse, on the steps facing Robson Square, Claire and I stood in the cold March air. She did not make a speech. She just said, "That's done," and shook my hand, and went back inside because she had another matter that afternoon. I took the SkyTrain home. The twins were born 7 weeks later at BC Women's Hospital. My mother had flown out from Hamilton and she was with me in the room. My son came first and my daughter followed 4 minutes later, and the sound they both made in those first moments, that first announcing cry, is something I will not try to describe, because I don't think language is adequate for it. Richard was not there. He has not asked to be there for anything since. His lawyer communicates with Claire about the support payments, which arrive on the 1st of each month without exception, because the order is registered with the BC Family Maintenance Enforcement Program, which has the authority to garnish wages and seize assets if payments are missed. The system works the way it is supposed to work when someone has made sure the system knows what it is supposed to do. My son is named Theodore. My daughter is named Margot. They are 8 months old now, and they have opinions about everything, about which direction they want to face when they are being carried, about the specific stuffed rabbit that must be present at all times, about the acceptable timing of meals. They are loud and certain and entirely themselves. My mother stayed for 6 weeks after they were born. My closest friend drove over from East Van every Saturday for the first 3 months and did laundry while I napped. A colleague from work organized a meal train that lasted 2 months. People showed up. That is the thing I want to say clearly. People showed up for us. What did not show up, and what I stopped waiting for, was permission. Permission to take up space in a courtroom. Permission to assert that my children's father had a legal and financial obligation to them regardless of whether that was convenient for his business dealings or his family's reputation. Permission to refuse a number on a piece of paper that was designed to make a problem disappear. Gerald Holloway thought $2 million was a ceiling. Claire Arsenault showed me it was a floor we didn't have to stand on. There is something that happens when you stop negotiating with people who are negotiating in bad faith. The dynamic shifts entirely. They were prepared for me to take the money. They were not prepared for me to know my rights. Those are not the same thing. And the distance between them is where the whole case lived. If you are someone sitting in a parking lot or a bathroom or a kitchen, holding a number on a piece of paper that someone handed you as a way of making you smaller, I want you to know that the number is not the offer. The offer is always, stay quiet, or find out what the law actually says. The law in this country says your children have a right to support from both parents. It says that right belongs to them, not to you, and cannot be signed away. It says income must be disclosed fully and honestly, and that a judge, not a billionaire's lawyer, not a grandfather with a commanding voice, decides what fair looks like. I did not go to court for revenge. I went because my children deserved a mother who understood the difference between a threat and a negotiation, and who knew which one she was actually in. Theodore is asleep in the next room as I write this. Margot is not, because she rarely is. I can hear her talking to herself in the particular serious way she has, like she is working something out. She probably is. So Wang Yi. Silence is not the same as peace, and protection choosing to protect your children through every legal means available to you is not aggression. It is the most basic form of care there is. I did not erase myself for $2 million. I filed first instead.